Like if I was walking with my husband late at night and I see a shadowy figure coming towards us and it's dark, I would normally go on the other side of him, just to, it's your instinct to try to have your protector protect you. We're walking with a stroller. I don't know where we're walking with strollers with shadowy figures, but just to give you, the emotional parallel, now I go and I stand in front and go towards the figure. It's like, it's very primal, that mama bear thing.
Hi, besties. It's Katie from Without a Crystal Ball. Something was just unsealed in court, and it has to do with Jed Wallace. And this made me think about his case because Blake's case against him was dismissed. And when the judge dismissed the case, he said that she can only refile a case in New York if she can prove that any action he took was directed at New York and it directly impacted her and caused her harm in New York. And she doesn't have any of that evidence. And he said she could file in a different forum, meaning she could go to Texas. And I explained to you that there was some issues with her going to Texas and her filing a countersuit against him in Texas and some obstacles that she had to overcome in order to do that in Texas. And I needed to get back to the beginning because when I was dealing with when we were dealing with all the lawyers, when it came to all this creator stuff, it was really clear to me that her team very much is trying to distance themselves now from this Jed story and say oh, no. Jed wasn't the only person involved. It was literally all the people were doing the smear campaign. It wasn't just Jed, trying to make it seem like Jed wasn't as instrumental as she had originally claimed. And when I got that, I was like, I don't think she's going to refile against him. And that's just my gut. Okay. And I said that to you yesterday, but I went through her initial notice to him when she wanted to do a deposition with him. And I noticed something within this filing that's very critical. And I also found something that was unsealed just recently, like yesterday. And this document shows that Jed Wallace was well aware that there had been this 17-point agreement. The 17-point agreement, though, does not show that any sort of harassment happened. It just is stipulations that she required to go back to work. And in fact, the email that Melissa Nathan sent to Jed said, these are the items noted in her I won't come back to work unless these are adhered to. Okay. And it goes through her entire demands, all those 17 points. Now, some of it's a little bit different than the final version, which might have been the red line version, but it was clear that it had a non-disparagement in it. It says there shall be no retaliation of any kind against Blake Lively for raising concerns about the conduct described in this letter or for these requirements. Any changes in attitudes, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work, as a result of these requests, is retaliatory and unacceptable, and we will be met with immediate action. The clause that's in that contract is attempting to say that the contract that they have extends into promotion and that anything said, any sarcasm, any tone, anything can be viewed as non-disparagement and can be viewed as retaliation, which actually goes beyond the federal law for retaliation and sexual harassment. And to be extremely clear, this document doesn't overtly express or state sexual harassment occurred. It simply is a list of her requirements to go back to work, which also includes requirements that, she have control over creative aspects of this film and that they hire people to deal with creative issues. In fact, creative issues is cited in points 10, 11, and 12. Number 8 has to do with COVID, which has nothing to do with sexual harassment. Number 1 is about an intimacy quarter, not implying anything that has done wrong. Requesting closed sets. No spontaneous improvising of scenes. Again, this has nothing to do with sexual harassment. It doesn't even state that anything occurred. It's just her requirements for returning to work, which again, 10, 11, and 12 have to do with creative differences. So anyone that would see this would see that she can't even, she's limiting them to even be able to talk about creative differences, which is, again, not covered under retaliation for sexual harassment. But even so, this is the clause that she's put into it to basically limit and silence speech of any kind on the end of Wayfair. It's a very robust disparagement, non-disparagement agreement, which is also pretty vague and has a lot of issues that could be contested in court. And the contents of this non-retaliation clause could very well become a part of the defense and whether or not it's even enforceable under the current law and if it extends beyond the law of what's under federal law for retaliation and sexual harassment. And then most importantly, Blake never filed a complaint with the EEOC for the federal government. So she can't claim certain aspects of the EEOC laws without filing a complaint with the EEOC. But regardless, all of this is to say is that Jed was aware that this non-disparagement agreement was in place. And thus, that would match the fact that Jed then claims that he took a passive approach. And it could also be why Wayfair took a passive approach. And they didn't respond to press because they knew that this non-disparagement agreement existed. And why on earth would you want to, disparage the actress that's your star in your film? It would harm the film that you make. Now, it would appear that leaks happened on both sides, on the side of Blake Lively, with Leslie leaking stuff to the press, and with Stephanie Jones, who works for Jonesworks, who was the publicist of the Justin Baldoni and Wayfair at the time, and claiming it was all Blake's fault. And whatever happened here, the disparagement appears to be, it could be anything that you say about her that's negative, anything, regardless. And then she's claiming that anything you say about her negative automatically means it has to do because she made you sign this protections that returns to work, which is again ambiguous. But why this matters is because I think the reason why she's not going to file against Mr. Wallace is because back in January, she filed a notice for a deposition for Jed. And when she filed this notice for a deposition in the state of Texas, this is what her belief was. The retaliation campaign relied on more than just publicists and crisis managers spinning stories. They also retained subcontractors, including Mr. Wallace, who weaponized a digital army around the country, including in New York and Los Angeles, to create, seed, and manipulate and advance disparaging content that appeared to be authentic on social media. They would then feed pieces of this manufactured content to unwitting reporters, making content go viral in order to influence public opinion, to safeguard against the risk of her, Miss Lively, ever revealing the truth about Mr. Baldoni. And then they planted, created, and amplified and boosted designated to eviscerate her credibility. And then they used this to bolster his credibility. And she calls this unlawful, retaliatory, and social combat. In fact, in her request for a deposition, she actually says nothing about a smear campaign, and it has nothing to do with sexual harassment. It has to do with breach of contract of a rider for her returning to work. Breach of contract. That contract does not say anything about sexual harassment. Based on the facts set forth, which include a contractual rider that prevented any retaliation of any kind, including disparagement against petitioner, the breach of that rider by employees and agents of Wayfair through a surreptitious social media and press campaign, the acknowledgement by Wayfair's employees and agent that Mr. Wallace assisted in breaching the rider and orchestrating a widespread campaign to damage her reputation, and that Mr. Wallace's efforts had in fact succeeded in shifting the narrative towards shining a spotlight on Blake and Ryan, damaging petitioner's reputation. She wanted testimony from him about his knowledge of that rider and if he knew that there was a non-disparagement agreement, not that any sexual harassment occurred. And knowledge, as the judge stated in his ruling against Jed, is that even if you have knowledge of something, doesn't mean that you took the steps to do something. So if there is a quote unquote conspiracy, discussing a conspiracy or having knowledge of a conspiracy doesn't mean anything if there's no evidence that a conspiracy occurred or that something was actually directed at New York and in New York. And even so, is legally does this contract hold water under federal law when it comes to sexual harassment and retaliation? That's going to be a question for the court. And I think very early on, the media got this right, where they noticed that this was really about the violation of an NDA, right? Did they violate their NDA by speaking about Blake? Did Blake violate her NDA? Because the NDA goes both ways. She most certainly had an NDA with them to not disparage them as an actress of the film. So again, it'll go both ways. But what she told the court in January about Jed after accusing him of orchestrating this is that the investigation may help to avoid unnecessary litigation. There is a heightened risk of inviting frivolous lawsuits in this case, where Mr. Wallace's attorney, Mr. Friedman, has repeatedly threatened to file suit against anyone who might bring claims against his clients based on allegations in her complaint. This is particularly relevant in light of the likelihood that Mr. Friedman's threats to sue are backed by another retaliation defendant, Mr. Sarowitz, who previously divulged at the film's New York premiere on August 5th that he was prepared to spend $100 million to ruin the lives of Miss Lively and her family. And if you recall, that statement, the judge stated, is not evidence of a conspiracy. It's a statement to a witness. It's not evidence that they did anything. And throughout 2024, Mr. Sarowitz, the founder and active director of Paylocity Holding Corp., sold significant amounts of Paylocity stock valued at nearly $100 million, therefore allowing petitioner to make an informed decision about any future legal action through a pre-suit deposition is likely to achieve the goals of reducing or eliminating frivolous litigation and promoting judicial economy that Rule 202 is intended to achieve. She stated to a court that without testimony from him, that it could reduce frivolous litigation. And then she flipped it and said that Wayfair has threatened to file litigation against her, which they filed a lawsuit against her and it was dismissed, and the other parties. But she sort of like confuses the judge there and says, like, listen, I'm not sure I have a case here. And there could be issue here that if I don't get this testimony, I could potentially be the one that files a frivolous lawsuit against him. So getting a deposition from him could achieve her from filing a frivolous action against him. And yet what did she do? She filed the action against him in New York without getting that deposition. And Texas has a law which requires that civil lawsuits are supported by competent witness testimony and evidence. The state of Texas has more robust laws about filing lawsuits, and these are within their civil rules of procedure. And it has to do with their signings of pleadings, motions, and other papers. And if they hold people in contempt if they file suits that have groundless and false statements and are being used to delay, they can be considered contempt of court. If pleadings are not filed in good faith, they can be sanctioned. They can be, if a person files a lawsuit and it is not filed in good faith and it's being done to harass or intimidate or for improper purposes, they can be sanctioned. And it's more robust than what you see in federal court. And because of these two different laws that she cites that are part of the civil rules of procedure, she can't go to Texas and file a claim and bring defamatory statements and make wild accusations if she doesn't know it's true and she doesn't have the evidence. So she needs substantial evidence before she can even file a lawsuit. I actually kind of like this law. I wish more states had this. But that's why she's trying to get it out of Texas, because as it goes today, she still does not have evidence that he did anything. And if she did, she would have provided it to the court. And the judge had all of this evidence because it had already been provided to the court. So the judge knows that Jed knew about the 17-point agreement, which still doesn't prove that he was retaliating against her, right? And the judge knew that he spoke with other people like Heath, and they have some of his emails because they filed those in court. And everything that's been filed under seal, the judge has seen. And still, with all the evidence that she has filed into the court under seal, none of that persuaded the judge that Jed took any actions against her in New York. And even so, all of the claims that she made that she said furthered the conspiracy to cause her harm, the judge said didn't actually prove anything. And also didn't prove that Jed knew about any of it. And even so, the allegation she made that they did these things doesn't prove that it actually caused harm to her in New York or that it actually harmed her at all. The burden falls on the plaintiff to prove the conspiracy or the theory, right? Just because someone talks about you doesn't mean that that reason that they talked about you is why your reputation went into the toilet. And her entire claim is that they're boosting and posting content, all of those videos that posted her in an unfavorable light, and it was based on her own behavior. They're claiming that they did that to tarnish her reputation. But people are just reacting to what they heard and witnessed her do, right? They're only reacting to her voice and to her statements that she made. And she refuses to acknowledge that she didn't talk about domestic violence in a way that resonated with fans. She's blaming the fan reaction to it as inorganic being done by Wayfair. But this is a reason why the Jed case is very at risk of going away, because on the one hand, she doesn't have any ties to New York to prove that he knew anything in New York. And on the other hand, Texas has these laws that bar her from bringing frivolous lawsuits. So if she goes away from Jed, what happens next? Well, she has to go after Melissa Nathan. And now that she has subpoenaed all of these different content creators, and some of the content creators are beginning to respond in court and say, we were not paid. We had nothing to do with this. And Cassidy O'Connell, she filed a motion for a motion to quash and said that she's going to be filing sanctions or reporting Ezra Hudson to the bar. Cassidy, and she denied that she was paid by them, did anything for them, spoke to them, anything. And she pointed out that they have no grounds to seek her information because they have no evidence or proof that she spoke to anyone. And she cited that they filed the subpoena in the wrong jurisdiction, which would be in New York when Google is a company in California. And because Google's a company in California, you have to file the subpoena in the state where the compliance is demanded. So as is, Google is a California state company, and they're being told by a New York subpoena that they need to comply. But under the law, it should have been filed in California. So that was one of the grounds, because she said it was filed in the improper place. They didn't have the evidence. They didn't go to the right areas of the court to get permission to unveil the identities of people that are anonymous on the internet. I mean, it was a very well-written argument. There were some parts of it that she took extreme lobs at the judge and at Ezra. And because she so vehemently denied it and demanded that it be dismissed and said, I'm reporting Ezra to the bar, it wasn't within I don't know, a few minutes, an hour, that Ezra and her team are then filing a response. And the response has nothing to do with Cassidy. Instead, it's that Melissa Nathan gave a list of people that she spoke to that were content creators, but she filed it under AEO. And it's a weird way to try to address this motion to quash without addressing it, because she's tackling the same issues. So she's claiming, she's trying to refute in a way that Cassidy was a part of this process. She's implying that Cassidy and Andy Signor are somehow being paid by the the Wayfair parties, which all have denied. And it's really trying to get around this idea that no, Tag is in contact with all of these people. She claims that Tag supplemented its responsive, identifying a number of individuals who have spoken publicly about Miss Lively and this lawsuit, apparently at the behest of Tag and other Wayfair defendants. Apparently. Now, speaking to someone and a content creator or providing a comment or providing background doesn't mean that you're speaking on behalf of someone. Okay. Despite the factual nature of this information, Tag unilaterally designated its response as confidential in attorneys' eyes only, thus obscuring Tag as the source of this information and allowing the Wayfair defendants to once again recast Miss Lively as the aggressor in pursuing subsequent discovery, which is exactly what has transpired. So, one of the statements that Cassidy made was that Blake is super aggressive in court and she's always filing these motions and she's always like complaining and getting all of these, like stomping her feet and throwing tantrums, right? And so their response is, well, they're only doing that because Tag has designated this as AEO. Apparently, at the behest doesn't mean that it's true. Okay. And then they say that during Tag's preliminary discussions, the council claimed that its responses constituted trade secrets, which, if disclosed, could somehow harm their business. And they're claiming that that's not true and that it's not a trade secret. And while trade secrets can be designated as confidential in the EEO, those protections are diminished for confidential strategies and other information related to the parties in this litigation. Tag's counsel has provided no facts to support their assertion that the identity of third parties could somehow constitute trade secrets, nor can they explain how this information could be so sensitive as to cause harm to Tag, especially where many of these individuals have already spoken publicly about Miss Lively and in this case. So again, seeding this idea that content creators are speaking on behalf of Tag. Now, it would be no different than Ryan Reynolds following pro Blake content creators like the ex-patriarch. He literally follows him on TikTok. Does that mean that Ryan is feeding things to the ex-patriarch? And also, just because someone speaks to a content creator and shares and they might give a comment to them, does that constitute a content creator creating information at the behest of them? Or is it an independent journalist seeking clarification and a statement and then publishing that information? They're viewing content creators not as journalists, but instead as people that only exist to slam and smear Blake Lively. And I will say without a doubt that when you try to diminish and reframe content creators in that way, you're attempting to say that content creators or independent journalists don't have the shield. They're trying to piece the shield of reporter privilege. So they're reducing us to paid actors instead of actual journalists so that we don't have protection under the law. And even if someone speaks publicly about Blake Lively and shares and reports on the case, does that mean that they're working for someone, or are they just covering a case that's a matter of public concern and being done so in good faith? Because I can say for without a doubt with me, I've never spoken to Melissa Nathan. I've never spoken to anyone at Tag or her affiliates. And thus, even if I had, just because I would seek a comment from someone doesn't mean that I am automatically doing something for someone else. I would speak to anyone that would support Blake and issue their statement as well. She claims that because people have sought comments from Melissa, that proves that they're part of a smear campaign. And then indeed, information has designated as confidential all relates to their work for Wayfair and are therefore plainly improper. The misdesignations are having very real impacts. And here she's the victim now of all of us. For example, if Miss Lively issues subpoenas related to individuals identified in Tag's interrogatory responses to marshal evidence about their involvement in the smear campaign, she will be hindered in her ability to meet and confer or respond to questions and will be unable to explain to such subpoenaed parties that the discovery directed towards them is based in part on the fact that Tag identified them. So she's trying to get around this AEO and claim that we're being subpoenaed because TAG identified us as speaking to her and working for them. And that's why they're being evasive with us about this. But that's not true at all, because Ezra Hudson told my lawyer without a doubt, or Ezra's team told my lawyer, that I am part of a smear campaign and being paid by Justin Baldoni. So this argument doesn't hold up at all. So that must mean that I'm not on that list, because she says right here that she wouldn't be able to tell my lawyer that, but she did. So how does she know that? She doesn't. I'm not on any list. I've never spoken to Melissa Nathan, ever. Content creators who have been subject to discovery have already painted Miss Lively as the aggressor in this lawsuit and have drawn a false equivalency between her discovery efforts and the Wayfair party's alleged smear campaign. Now they go after Andy, and they're directly implying that Andy is on Melissa's list. So they're basically, without saying it, in my opinion, breaking the non-disclosure agreement of the AEO and doxing him and saying he's been paid by him and working for them. One subpoenaed content creator even went as far as to record a call with a receptionist from Miss Lively's attorney's office without express consent and then posted the recording on YouTube. Seeing Popcorn Planet, it's real. We called Blake Lively's lawyers. They lied to us. This content creator further used the recording to make false inflammatory remarks about Miss Lively and her counsel, and is seeking to fundraise based on the recording and his remarks. I think his fundraising has to do that he's being improperly subpoenaed. That's just what he's posted publicly. The content further used this. The bottom line is that the concern about being hamstrung is being able to tie her discovery to the Wayfair party's discovery responses further exacerbates public backlash against Miss Lively, which she should not have to endure when there's no conceivable privacy interest that TAG and others are protecting. History is now at risk of repeating itself because TAG's misdesignated interrogatory responses. Miss Lively is yet again being forced to battle an untraceable campaign, unable to defend herself against misinformation online. While TAG may have been able to obscure the contacts in connection with the initial smear campaign, it cannot do so here. For these reasons, she asks the court to compel TAG to de-designate its interrogatory responses as confidential and attorney's eyes only under the party's protective order, and make clear that any similar confidential and AEO designations the other Wayfair parties may seek in use of this in connection with their responses due on July 18th would other likewise be improper. So what she's doing, in my opinion, is she's indirectly responding to Cassidy O'Connell and to Andy's video and saying that they are part of the smear campaign and they are lying, and we have proof because TAG has said that they have spoken to them and that we can't answer questions. She will be hindered in her ability to meet and confer or respond to questions and will be unable to explain to such subpoenaed parties that the discovery directed towards them is based on part on the fact that they were identified by TAG. Yeah, that's not true. She met and conferred with my lawyers. She met and conferred with Shasty's lawyers. She has met and conferred with multiple lawyers. And she has told all of us that they have proof that we are part of the smear campaign without providing us any evidence of it. And what's even worse, though, is that they won't even identify any videos that we've posted that proves that this was boosted for them, or that this was done for them, or that we were even paid. They're just saying, we know it and you're it, and that's the story. It's not preventing them at all whatsoever. And I never spoke to TAG, ever. I've never spoken to Melissa Nathan. I've never spoken to any of their representatives, any of their employees, no one. The only person I one time sent maybe a text on Instagram saying, hey, that's it. TAG's never responded to me. They've never emailed me. They've never messaged me, nothing. So how am I working for TAG if I've never talked to them? It's just trying to misdirect things. And even again, if people did talk to TAG, is that against the law? No. I mean, have her attorneys not spoken to the press? They have. Has Blake not worked with content creators? She has. There's videos of her on TikTok working with social media influencers. She's using social media influencers to help promote her alcohol lines. I mean, just because you speak to content creators doesn't mean they've done anything for you. It's just a leap, a very big one. So Ezra's response is, don't file the sanctions against me, Cassidy, because I have proof that you're on this list. And hey, Andy, you're fundraising based on lies. And now all of this backlash is because we can't actually tell you why you're being subpoenaed. It's crazy. Absolutely crazy. Absolutely crazy. And again, getting a statement from Brian Friedman, getting a statement from Melissa Nathan is not evidence of a smear campaign. It's just trying to control speech and criticism. And many of us are just independent journalists doing our job, and this is a threat on freedom of speech. And Blake Lively is a public figure who brought a public lawsuit in a federal court. Anyone has the right to speak about Blake Lively, Ryan Reynolds, or any public figure that brings a lawsuit into a federal court and uses federal resources and wastes taxpayers' money. We all have that right as U.S. citizen. It's called freedom of speech. And the continued assault on freedom of speech by Lively and her attorneys is really shocking. And at the very end of her letter, I think I just want to end on here. It says, while TAG may have been able to obscure its contacts in connection with the initial smear campaign, it cannot do so here. She's yet again being forced to battle an untraceable campaign, unable to defend herself against misinformation online. She is stating that the initial campaign, that wasn't in a campaign, has been it's untraceable. Blake has no evidence. While they may have been able to obscure its contacts in connection with that campaign, they can't do so here. They're all but abandoning what Jed did because they can't provide evidence. So now it's content creators who are reporting on this litigation. And right now, all I'm doing is reading a public record. That's it. And saying what my opinion is about this and telling you guys that I'm not being paid by anyone. And that public discourse is being threatened, and Blake is claiming that misinformation online and opinions online based on what she's doing in court is Wayfair telling us to do this, and it's not. She's making herself the victim of us, which is a Darvo tactic. She's attacking us. She's going after us. She's trying to get our bank records, and she didn't want to give up her bank records to Wayfair. So she wanted privacy for herself, but she doesn't want privacy for us. And now she's the victim of us, and we're doing this for Wayfair, not considering the fact that I'm just a reporter reporting in good faith on a lawsuit that was brought in a federal court between two public figures that has taken over public interest and is a matter of public concern. That's not a smear campaign. That's independent journalism. So what are your thoughts about this? Abandoning the claims against Jed and now trying to focus on to us as the content creators? Do you understand why now they're scrambling? Tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed. And if you'd like to continue to support us and our legal fight against Blake Lively, make sure to hit the thumbs up, comment, like, and share. And as always, you can send super thanks if you'd like to donate. We have a Venmo at Without a Crystal Ball, or you can use our PayPal link. Thank you all so much for watching. Bye, guys.